Good afternoon, listeners. We are here at Lech.co.za and would like to welcome you to a very, very, very special podcast because we have a very interesting and well-experienced a guest. His name is Braam Botha from JA Botha Attorneys from Bethlehem. And he is I actually got to meet him via email about a year or so ago, maybe a little bit longer, regarding my research on EMF, and he's actually conducting his doctorate now in law and specializing, looking into the EMF area or non-native EMF for South Africa. And he's quite a practiced veteran attorney with specialization in commercial law, company law, consumer protection law, human rights, NCA and corporate governance, along with environmental impact law, labor and employment law, and organizational development law and administrative law. I mean, he's got it, and he's a really passionate man. He's got a lot of sincerity with his work and always wants to look out for the best for both parties. And we're fortunate enough to have him today to share with his experience, his recommendations, what he's finding with his research. And Braam, thank you so much for being with us here today.
Thank you, James. It's a pleasure to have at last met you live. So thank you so much for inviting me.
What I wanted to have our listeners find out more is, why do you have an interest specifically in non-native EMF and the law?
It's quite an interesting situation that unfolded. My wife is a psychoeducationalist, and she specializes and works a lot with children that have learning disabilities. And during the course of last year, actually sort of beginning of last year, she had more than one child that suffers some kind of a syndrome, and we actually couldn't find out what it was. And it's still difficult to say, whether EMF played a role in that, but it was more related to screen addiction of laptops and mobile phones. So that actually triggered my interest in the subject, because we were trying to look for answers as to what actually caused this. Because we couldn't find actually some real solutions to the problem. So that generally plays a very important role. In addition to that, my wife and I are also involved in sharing information with parents in parenting courses with regards to a lot of issues, and amongst which is the whole issue of screen addiction, or electronic screen syndrome, as some people call it. How to handle electronics in a proper and in a mindful, responsible manner. So that combination actually prompted my interest in the subject, and I decided to investigate further. So the bigger part of last year, I started to investigate done some research, and decided to enroll for further studies. That is where I'm having here at.
Oh, that's great, and it's very interesting how you have the screen addiction, and with the literature, it tends to discriminate between different types of EMF, and the blue light emitted from mobile phones and computers actually is a non-native EMF. And the effects it has when we able to properly look at it through biophysics, using physics to explain biology, it actually triggers that addiction problem in the brain. How to adjust the metabolism and the glucose, and there's a lot of related to opioid addiction problems. And it was the patent for it actually was a couple of decades old, was specifically designed for that very reason. And it is harder for that addiction part, because the way it affects the dopamine in the brain and other chemicals, that in a way it makes a person dumber, because it removes the ability to think laterally. So that means a person's more narrow, focused minded. And whereas for sort of yes or no, And with the issues with addictions is that a person could be harming themselves, but they're not fully aware of it or why or where the causes are, and that just becomes a snowball effect. So it's very challenging to deal with anyone with an addiction because there's this defensive aggression with it, and only through processes of addressing mitigation options, of navigating those non-native EMFs, is the person able to sort of come around and improve and increase their lateral thinking. Then they start to say, okay, I want to actually avoid this technology. They're having a different association to it. And it's complex because, as you say, you're going back into studies now again, and it's so hard to sift through the literature and finding actual, papers that aren't, using industry funded or lobbying or different PhD, because it's a very multidisciplinary field of research. And the issue with PhDs is that typically it requires one to become highly specialized in a very narrow focused field. And the moment you try to bridge it out, the beating stick starts coming out from your colleagues.
Yeah, that's true.
So why don't you tell me a bit more about, what are the details and findings so far in your doctorate, and sort of, how that's relating to the outputs and reviews from my thesis, because you're very kind to give a very thorough criticism and review of it before it was examined, which was extremely helpful. But Josh, tell me more about sort of the views of the research of yours, what's happening, coming about, the rooms for improvement of sort of contribution from mine, and, sort of what you see going forward through this completion of your doctorate.
Yeah. Okay. It was quite interesting for me to find such a wide divide, actually a gorge between the two sides, the industry-funded scientific research that was done on the one side and those on the other side, like the EMF Foundation of South Africa, that obviously puts the emphasis on the dangers and the health effects of that, with which I fully align myself. And that is actually also part of, or the main aim of my studies and doctorate, is to look actually at the health effects that EMF exposure may have on individuals, and especially children during their early developmental stages. What I also discovered is that courts, unfortunately, do not apply the principles consistently, and it differs from country to country. If you just look at some of the principles applied by the American law versus that of the European nations like Italy and France, there's quite a difference in the approach. The one is more empirical, the United States, for example, whilst on the other hand, the European community or judicial system focuses more on principles such as the precautionary principle that originated, as you know, from the Rio conference or summit. So it's really quite a diverse field, as you have said earlier on. But my studies at this stage, I'm still sifting through a lot of information and some contradictory information, obviously. The risk, obviously, for me is that one could so easily go too wide with these type of research. And I want to narrow it down, especially as far as health risks are concerned on the one hand, and on the other hand, the legal protection that current legislation or the non-existing legislation, certain recommendations with regards to legislation and how the radiation levels and information and awareness of the public could be enhanced by means of national legislation.
And so how would you see South Africa's legislation compared between the US and Europe? So I know we have Brexit, and we meant to have a lot of financial and policy processes similar to Russia and Europe and that. But, in terms of industry development seems to be very heavily weighted on the American side. So what is, from your experience in the law, and, it is challenging because when the Constitution was drafted, it had a lot of vacuous elements in, where in terms of things have to be done in context, and you don't know what good is until you know what bad is, and vice versa. And they weren't able, the founding forefathers weren't able to foresee, how technology would run away and this proliferation of it, with the benefit of connectivity, but also the potential health aspects. So where do you sort of, from your experience, see South Africa lying between the two extremes?
Yeah, I think what is important to remember, for me at least, in studies of this nature, is that any potential claims from the public, like you and me and children and so on, the general public, as you call it in your thesis, the public interest, actually revolves around a delictual question, whether the elements of a delict are present. And I've found at this stage, at least this early stage, that to prove some of the other elements and requirements to establish delictual liability are not so difficult. The most problematic one, as I've discovered, is the one of causation, whether there's a logical, scientific, and a direct relation between and connection between the injury or damage suffered by a specific person on the one side, and on the other side, the evidence of or the presence of adverse radiation and its effects on a specific human being. So that causation thing is quite, I think, the most challenging issue on the whole, as far as my perspective from a legal point of view is concerned. And again, in America, a country that litigates so easily, their courts have, until now, as far as I could have established, not granted actually delictual successful claims in favor of claimants, purely for the reason of a lack of causation and evidence. And that brings one again back to the industry-funded scientific research and the non-industry-funded research. And, well, time will tell as time moves on, which sort of school the courts will accept. But having regard to the precautionary principle, I cannot see why the courts do not only, but as place more emphasis on the precautionary principle than the clear, substantiated scientific evidence. There is a balance between the two, but my argument in my thesis will strongly advocate the position that irrespective of real scientific proof of the adverse effects, the precautionary principle must be applied as a precautionary measure, obviously. And that is what our Constitution also has in mind. If you just look at Section 24, I think, of the Constitution dealing with environment on the one side, and Section 28 dealing with the rights of children, those rights are entrenched as rights, and any infringement to those rights may bear certain consequences, one of which could be delictual claims, either from the cell phone companies and those type of people, or government itself for its lack and its inability to formulate effective legislation that regulates the radiation levels of these electronic devices.
And yeah, it's very difficult with the causation thing, because it becomes a thing of how well publicized or unpublicized these different techniques are. So historically with the causation, it would come down to the claimants would use a thing called algorithmic medicine, and that's sort of looking at statistical correlation, only using one specific kind of disease or issues. And it's very hard because depending on how the study is done, all these elements, it can be very deceiving of what the effects are. And that's why again this year I switched my PhD more towards biophysics, because with biophysics you're able to use physics to actually explain biological function. What's happened with that is in that field, it's been shown unequivocally the effects that radiation or non-native EMF has on specifically mitochondria. So, in medicine, biological chemistry, it focuses more on the higher level of it. But when you look at quantum biology, looking at the electrons and protons, there you're able to see the exact effect and the issue on mitochondria. And that's why, with that, we're able to actually see that with non-native EMFs, it's the leading cause of obesity and diabetes in persons today. And, there's a whole bunch of other diseases that we see with it. So it's all about the articulation. There's a very famous scientist who also actually then became an attorney named Dr. Andrew Marino. And he's been a number of US cases, particularly on smart meters, where it's been successful. But the challenge again is that it's not well publicized after the fact. Even with me being caught and with a judicial review showing that non-native EMFs do have the capacity for biological effect, it's not publicized afterwards, or it's not really shown. So it makes it more difficult to sort of take it through forward and build it. And it's challenging of how it is or where the metric lies. And it's always going to be a problem because it requires different avenues of explaining. And when you're trying to get a testimony expert on the stand, it is difficult because they might bring a doctor, but most doctors are very good at dealing with chronic issues. Just based on their training, like if it's a heart, if they have to do open heart surgery or breaking a limb, and repairing it and those kind of issues. But when it comes to managing diseases like diabetes or blood pressure, it's something that's not as well in their skill set based on the training, and many doctors don't actually like to look at physics or learn about physics. That's why the field of mitochondrial medicine is only about 5 years old now. But with that, it's actually able to show these more direct effects, and that's why biomarker tests and genetic screenings have been a lot more successful in showing those. And particularly, but again, the issue is these are only really being published more so in the last few years, 2015, 2016, 2017, now 2018. With the release of the final results from the Ramazzini and the National Toxicology Program studies, the US and the Europe. And, there it shows the classification upgrade of the non-native EMF to a type 1 carcinogen. But the difficulty is there was a meeting afterwards with the directors to the press of the directors of the research. And they said, with the advisement is based on the results, keep a cell phone away from children, especially pregnant mothers, and developing infants, because of the radiation has a different physics effect with biological organisms. But they disclosed, that they are only policy advisors. They do the research. They don't actually enact or create policy, and that's why it falls to the public to actually, voice their demand for this change in policy, and also approach the courts to mandate the changes to the law. Like you said, in South Africa, it's difficult. There is some laws that can be used and others that isn't specific to it. So maybe you could just give us more. You mentioned the Constitution, but also maybe more elaborate on what rights or what piece of legislation are available that can be enacted to provide protection. For example, if it's going to be administrative law, or if it's going to be the Promotion of Equality and Prevention of Unfair Discrimination Act. What's your views or experiences on ideas?
Yeah. Before I get to that, may I perhaps just say that just from a legal point of view, it's impossible to successfully, I believe at this point in time at least, to successfully get an award for compensation or an order for compensation or some other directive order from the courts without the expertise of guys like yourself and others worldwide that goes into the deeper and the more technical, mathematical, scientific areas of this. I don't want to tread on that field. It's not my expertise at all, but I think it's important to just make the point that there will be, and worldwide that is the case, a very important partnership in a sense between scientific research and the law on the one side. And that partnership needs to be strengthened for purposes of enforcing certain laws and rights of individuals. Turning to your question about legislation, obviously South Africa, one of the main, or the main legislation that we have that protects not only the environment but also the humans like you and me is obviously the Constitution. In addition to that, the PIRE Act, as you know, to get information from certain organizations and mobile companies. However, as you also know and have experienced, and actually you've pointed that out in your dissertation as well, that companies are very reluctant to disclose information and hide behind the confidentiality clauses or restrictions or limitations in terms of the PIRE Act. And obviously also the Promotion of Equality and Prevention of Unfair Discrimination Act. So these mechanisms are there, but just as we have very strong opinions as to why certain companies should disclose information where the right of a specific person is likely to be threatened. To the same extent, those companies have their experts that tells them, and the courts obviously, that disposing or making available that information to the complainant is actually infringing their rights in terms of PIRE and other legislation. So again, the courts will have to play that balancing act at the end of the day, and it's difficult to predict with if a court, for example, South African court, disregard the importance of the precautionary principle. It would be very difficult, as the law currently stands in South Africa, to succeed with a claim for compensation, either in terms of a delictual claim or in terms of the Occupational Health and Safety Act as a disability benefit, like the courts recently did in Italy. Yeah, so those are just some of that. Then obviously the whole environmental law and legislation are also involved. The environmental impact studies and SPLUMA legislation. All of those legislation plays a particular role, obviously depending on the type of threat or type of action or non-action omission that one wants to challenge in terms of our current South African law. As you know, the the Telecommunications Act, I mean, if you go through, I've just done a check through the existing legislation, there may be about 26 laws that may be applicable to the whole question of electromagnetic radiation and possible adverse effects thereof to humans.
And when sort of one feels that their rights are being violated or need to be protected, what administrative steps do you feel one should follow? So, be it the erection of a tower, of a cellular transmitter, or it being a sub-transformer from a power station, or even Wi-Fi in a school. What is your recommendations on what one needs to do as a citizen to actively engage before approaching an attorney such as yourself?
Yeah, I think obviously one of the important things, as I've mentioned earlier on, is if somebody comes with a complaint of that nature, it must first sort of be established scientifically whether the condition of the person suffering a specific disease, for example, whether that was as a result of the electromagnetic radiation in a specific area. I believe that is an important thing. Only once that has been verified in a sense, or at least on a balance of probabilities, the lawyer should come in and to look at what has been established in terms of the science versus what we can do in terms of the law. And in terms of the law, obviously, there are a number of remedies, and I also cover that in my thesis, which ranges from a directive court order, or a mandamus, as we call it, to instruct a specific company to demolish or to break down a specific installation, like a cell tower, for example. And that has happened quite frequently in Europe and other countries. Even in South Africa, I think there are one or two instances where I think you were also involved in. So that is one kind of legal remedy. The other is obviously compensation. Should you suffer an occupational disease in terms of the Occupational Health and Safety Act, then that route will obviously, or avenue will also be available to claim compensation from the compensation commissioner. If it is not occupational related, then one will have to look at the intellectual liability of the company or the body that actually causes the radio electromagnetic radiation adverse effects. So there are various types of things that one must consider before consulting with an attorney. But I think if attorney is somewhat clued up as far as these things are concerned, then he will be able to at least advise his client, listen, we must first get some sort of scientific proof, or whether there is no possibility of succeeding in a case like that.
So when a person wishes to approach an attorney, I've heard lots of stories where persons would go to attorneys where they have these concerns, and not everyone is as ethical as you in the industry, and they would just want to gather client as much as possible, and then after 20,000-30,000 rand, they're saying, well, actually, I don't know much, I can't really help you. So, when a person's wanting to sort of do their homework or vetting to find the right partnership, because this is, it's the first step of 1,000 steps. It's a very long process. Yeah. And, it can be a difficult, abusive process to the client. And, having an attorney shields them and protects them from a lot of the unnecessary stresses with such a situation. So when a person wishes to approach or seek or find one, what is your recommendations on sort of questions or feelings or things to check out or find out with this when they do seek legal advice?
I think what's important, and that is for me personally, obviously, is the whole issue of ethics with regard to questions like this. If I don't know something on in respect of a particular field, first thing I will say to the client, listen, I'm not an expert in this field. Let me recommend you to person A or B who actually specializes in these type of things. So again, that brings me back to the point I made earlier on with regards to partnerships between you guys that are far more scientific and the legal profession. Currently, I don't know of any attorney or advocate that has solid background and experience with regard to this specific topic in South Africa, at least. So I think it's important to build a network also with international colleagues in my particular profession, to learn from them as to how to approach any type of complaints that a client may have with regard to his health or well-being.
Let's try discuss the scenario hypothesis, which I understand relates to your doctorate. Like in the movie Star Trek, it's about discerning or deciding, do the needs of the few or the one outweigh the needs of the many? And with the different legislations, we have the argument of fair versus unfair discrimination, or like you said, a company with a buyer has the rights to protect their confidential information, but then there's also the rights of an individual or the public who wants that information. So in this scenario, say they're wanting to install, education department wanting to install Wi-Fi, a very powerful Wi-Fi router, and wireless tablets throughout the classroom, and from the legislature, it's important to have communication, education, with less cost of textbooks and connectivity. But on the other hand, the way the technology is set up, it's not necessarily geared for younger children or for members of the population that have a higher intolerance to the non-native EMF. And that there are alternative configurations or mitigation options that can be installed, like blue blocking filters, LAN cable, fiber optics, and such like. So, how would one deal with a situation? I mean, if a client came to you with that kind of situation of the child is hurting or there's a proposal for it, and like you said, even if it doesn't necessarily have to go to the point of installing and see what happens, one could employ the precautionary principle of having certain changes made with it. So how would you negotiate or handle the needs of the few of the one versus the needs of the many? How would that be?
Yeah.
How is that handled in South Africa?
Yeah. Well, obviously, everything again boils down to the content of the Constitution of the Republic of South Africa that has a clause, we call it the limitation clause, that says that any of the rights, either in the Constitution or any other legislation, could be limited or restrained or mitigated to some extent. And the factors that are involved in limitation is actually a weighing up of the interests of various interest groups. But our courts have in the past, with regard to other issues, obviously non-related to EMR, have made decisions where it says that in a specific context of facts, it is sometimes necessary to to place the value of one particular individual or the interest of one particular individual above the interest of a number of individuals if, and that's the proviso, if it is warranted in terms of the law that it is right and justifiable and reasonable to do so. Now, those terms are extremely technical if one looks at the jurisprudence of our courts that dissects these type of terminology. But to answer your question, it is definitely not unlikely that a court will interfere in a scenario that you have just mentioned. I mean, let's just look at the following. If a cell phone company wants to erect a base station that will supply 100,000 people of internet access, but in the same breath, there are 5 individuals living close to that base station that have very strong suspicion that their health is deteriorating as a result of the presence of that tower. In that particular case, I have little doubt that a court will lean backwards rather to accommodate the 5 persons if science can obviously show that the presence of that particular base tower is the cause of their illnesses. So it's a balance again between not only the different rights of different groups of people or a company or a public institution, but also a balancing of the interest and the adverse effects that one group may suffer as to the other person or institution.
I think, like you said, the technical word reasonable accommodation is a very key one because, like you said, there might be 5 individuals versus the 100,000 or 1,000, whichever the number may be. But that also comes into, like I said, engaging with scientists of saying there's the thing called a LARA, as low as reasonably possible kind of scenario. So, in the Constitution or the Telecommunications Act, it says that one must be able to have voice or data communication, but doesn't specify that it must be 1 gigabits per second versus the ability to have a call. And with that, the configuration of the transmitter, as is done in other countries, would be altered according to the status of the population or vulnerable population within the area. And I assume that if that's then brought to the table and for the court, for the judge to decide, for him to review, okay, we will erect the transmitter, but there would be certain limitations that must be imposed in order for the needs of the many to still be furnished. And that's also the reason why when the World Cup occurred, fiber optics was seen as the only viable solution, not wireless transmissions going everywhere. In order to have those speeds and the issues of privacy and security and guaranteed infrastructure. And then the wireless became a piggyback on that backbone infrastructure of the fiber optics. So it's about, like I said, I guess it comes to that merging between the technical scientists and engineers with the lawmakers or the legislature of how can it be merged together to benefit both parties and develop newer or better technology options that's going to benefit the whole. Because what we're finding with the studies and the effects of non-native EMF is that with the effects being non-linear, you might have initially those first 5, but the rest of the population will have other diseases that actually are very costly to the state in terms of medical costs. And that's why in Paya with Judge Holm was really on with BHP Bulletin, there was that description of social accounting and how that there's potential of coal fires or furnaces in the homes, and there could be issues with asthma, and that's going to be a burden on the state in terms of costs and the hospitals. So these are areas also to be argued or considered and negotiate through the process. That with the precautionary principle that diabetes initially or obesity doesn't seem like a very bad disease, but now with according to Diabetes SA, diabetes is the second leading cause of death in South Africa, of which the physics explains there's a strong correlation with the non-native EMF having that aggravating effect on it. But I guess it comes also down to social perception because, with the media and the marketing, everyone gets more scared of the cell phone towers. And it might be stuff found actually, your magnetic fields, so your power lines, your sub-transformers, or the wiring in your home, that can have actually a much greater or worse impact, and even the blue light, even more so than a cell phone tower out there. It just has that visual fear or propaganda surrounding it. And it's very difficult to navigate these scenarios and how to manage that fear. And that's what's always the most important to try. I found these situations, negotiate or request a meeting with your public officials and your industry counterparts. But if they refuse or they decide to bully the argument, then they're having to approach the courts to be a mediator and to be the objective party in negotiating this discussion, which is very unfortunate. It's a very costly process, a very long process, can take years, and difficult.
Yeah, it's so true. And I mean, if while you were mentioning that, especially legislation like the Spluma legislation and environmental planning and town development and these type of things, the logistics as to where these base stations should be erected has become a very contentious issue, as you know, and there's no there's no or very little public participation in those decision-making processes. So I foresee that in the near future that these type of disputes will more and more occur on local government level, because that is actually where the paw points the fan, so to speak, and where individuals are experiencing the adverse effects of that, if they are obviously aware of that, because that's my experience. People are totally ignorant and unaware of the dangers of EMR compared to other information that just is so available wherever. Just for interesting sake, the other day I was looking at my phone. I upgraded, and in the box I found a leaflet that says, for radiation, for more information about radiation, click on a certain icon after you have downloaded the information, and then you will find out what the situation is. I mean, that is ridiculous. How many people actually are aware of such a warning? And those are the basic things. I think if people just read those things, like a cell phone is only safe being tested at 20 millimeters from your skin or your head, it will make people think differently. And that's what I also try to achieve by means of public education and speaking to different interest groups.
And it's very difficult with the social currency element involved with the phone. Like I said, how many people actually read it and also be able to understand it is difficult. And when they do understand, or they have this curiosity or fear and they wish to voice it or converse with it, they are often receptive of systemic abuse of their human rights, where my previous supervisor is telling me that he was giving a talk to some high school students, and his phone rang and he pulled out this brick of what was or quarter brick of a phone, and all the kids were laughing at him and taunting him and saying, "What's wrong with you? Like, oldie kind of thing. Why do you have such an old, out of date thing?" And the kids are showing their latest smartphones. So and the thing is with that, like I said, the screen addiction issue, if the kids have it, or the social currency where they're addicted to being their status in their society is registered by what they have or how they're sharing it, it's very difficult for them to speak out or even voice out to their parents if they're not feeling well, or they're having issues with concentration with using the device, or emotional outbursts. And one has to deflect to something else or following the mainstream. I think that's where it's difficult, that's why we actually have the law develop, is that we don't want a country to be run by Facebook and social media, because it becomes, sort of the Roman times, and what the people want, it doesn't exactly protect them. And I think that's where you said, where Europe is different, where it works on principles, and, it might be a social thing and it might be a phase, but we're looking at principles of what's going to structure and keep society together. And these laws is what's there to help protect everyone. Just because everyone has a Porsche or Ferrari capable of going 240 k's an hour, we still mandate laws to protect them in certain areas, not only themselves and those occupants within them, but the public that's next to or on the roads as well.
Yeah, it's so true. It's so true. I believe there's a huge task on people like you and me and a lot of others to create awareness in the public domain of these adverse effects and possibilities. And I think that's where an institution like EMF RSA does a very, very good job. Just one of a number of institutions in South Africa, at least. So I think that is very important.
Well, Braam, thank you so much for donating your time today. It's been really, really helpful and insightful. If you have any last piece of advice or things out there that you think would be beneficial to the listeners?
Yeah, I think I may perhaps close by saying this, that in the times that we live in, information and knowledge is about the first and the last. So we must educate as many people as possible to become aware of the existence of electromagnetic radiation and the possible and already proven adverse effects on their health and their well-being.
No, great. Thank you so much. And we look forward to having you again on the show in the future once your PhD is more developed and also published. And look forward to seeing how those developments come through and also your experience going forward with the law. And please let us know so we can have you back on the show and to share these insights as you experience them.
Thank you so much, James. It was a privilege to have met you and share some ideas. I'm still in the process of learning. So it's a long way for me as well. But thank you so much for the opportunity.